Good afternoon, everyone, and welcome to today's discussion on civil litigation. Yes, we will be discussing civil litigation today, and uh, this is one of the main practicing area in the legal system of the United Kingdom or England, whatever you can say. So we have got today the expert on civil litigation, Mr. Sushanta Saha. He has got a very vast experience on this side of practice. He's the principal solicitor as well as the director of Avista Solicitors. Mr. Shaha, welcome to today's discussion.
Thank you, Joydev. Thank you for having me.
You are welcome. So, if I just start with the first thing, when we say civil litigation, what does it actually mean?
Civil litigation, basically, it is a legal process in the UK when there is any civil dispute between two parties, whether it's individual or between two companies, then either
Mhm.
party can get damages or compensation from the other party.
All right. So, how is it different from the criminal litigation?
As you see that criminal litigation, people doesn't seek for the compensation, they seek punishment. But
Hmm.
contrary in the civil litigation, people either seeking for the damages or compensation or a specific performance, mainly money claims.
All right. So, you have got a vast experience in this side. So, if we just talk about money claims for today, because this is like different area and sectors in the civil litigation side, this is a vast area. So, if we just talk about money claims, so the word money is there, but what actually money claims are?
Okay, you need to understand first why one party is claiming money from the
Hmm.
other party. There must be a dispute between the two parties, whether it's
Hmm.
breach of contract or something else or neighboring dispute. Wherever there is dispute that people cannot settle between themselves, then one party, as per the law of England is concerned, they need to first bring the pre-action protocol, like sending a letter before action, and
Hmm.
then they are free to take the other party to the court and claim money as compensation, or can claim for a specific performance of the contract or damages.
Hmm. All right. So, what are the common mistakes they do when I mean, the normal people, the clients usually think about money claim? What are the common mistakes they usually do? What do you think?
Okay, it's a common mistake for general people is not to keep the record that why the dispute actually has arisen between the parties.
Hmm.
Like, when they form the contract between the two parties, one party relying on other parties, whether it's word of mouth or the agreement. So when there is a agreement, they have to have keep the document in hand. End of the day,
Hmm.
when any party is seeking the relief from the court, they have to prove their claim. And how they
Okay.
can prove is their word of mouth is not sufficient. They have to prove through the evidence, whether it is the agreement itself or correspondence between the parties, like emails, WhatsApp messages, or receipt, bank statements. These are all, very valid evidence between the parties. So they got to keep solid evidence with them to prove that they have a valid claim against the other party.
Hmm. All right. So, I mean, when you think about money claim, you have said that we need to make sure, I mean, the clients need to make sure that the documentation is there.
Mhm.
So, I mean, if they have the documentation, does that always mean that these things has to be solved in the court and the court will decide upon the documentation, or the parties can sort it themselves as well?
Okay. law in this country is very clear. Law doesn't, encourage you to take the matter straight away to the court. That's why I said
Hmm.
in my uh, last sentence that pre-action protocol. What it is pre-action protocol? Before you take the matter to the court, you
Hmm.
serve a notice before action. Okay,
Okay.
so that other party can defend themselves, and if they cannot
Hmm.
reach in any amicable settlement, then only civil procedure allow us to take the matter to the court as a last resort.
All right.
It's not like that we are having, just kind of altercation and I will see you in the court. It's not like that. There is a, civil procedure that we all got to follow before we take the matter to the court. And for lay people, we always encourage them that please, please, please keep the evidence available. End of the day, it is your claim or it is
Hmm.
your matter that you need to defend. How do you defend? Without evidence, you cannot defend. Your words of mouth will stand as just single piece of evidence only. But you have to
Hmm.
provide the circumstantial evidence that exactly how you want to defend or how you want to pursue a claim.
Hmm. So we have seen people delaying long time before they make the claim. So sometimes we call that you cannot make the claim because you are barred by limitation. So what
Mhm.
does it actually mean?
Okay, it is a very vast subject. Just for this small session, what I can tell to the audience that if you wish to pursue a claim against anyone, you must bring the claim within 6 months, sorry, 6 years, within six
Hmm.
years. Then it will be time barred. So if you genuinely have any claim, so make sure don't delay, must consult with the solicitor and bring the claim within 6 years.
All right. So yeah, there are some exception, but it depends on the factual things. So yes, if someone thinks that they have a claim, the first thing they need to decide whether they have got the limitation period or not, and
Exactly.
then the merit and other things. So yes, this is something the lay clients are, I mean, they do not understand or probably they do not even consider. So it's the solicitor's job or sometimes the public access based that they deal with it. Their job to deal with the limitation. So definitely the client and the lay people should seek legal advice if they have got a claim. So
Very true.
yeah, last question to you. I mean, we have seen that there are different types of civil courts in this country.
Mhm.
So if a matter goes to the court, for example, I mean, how does it, I mean, it calls jurisdiction definitely, but it's a legal language. If you can explain how the court thinks that which court will try which matter, how they do deal with that, and how is the
Okay.
first consequence.
Nowadays, life in the UK for the civil claimant, their life is so easy. They can pursue the claim through the online as well. Okay.
Hmm.
But end of the day, the court will allocate that where this case will be heard and which court it will be dealt with.
Hmm.
Mainly is depends on the value of the claim. If it is a small claims, like claim threshold is 10K, then it will go to the small claims track. Okay. But
All right.
if the claim is like for from 10 to 15K, then it will go to fast track. But
Hmm.
anything 25K to 100K, it will go to intermediate track. And any
Yes.
complex case, it will go to multi track, as we all know. But end of
Hmm.
the day, when the case will be allocated, court usually decides where the claimant lives. Usually, court will be, heard by their uh, county council court.
All right. All right. So last question to you. I mean, it's not a question. So I mean, civil area, civil practice area is really vast, and my claim is not a small as well. So if I ask you because you are an expert on this side, so what are the three main practical advice you would give to the lay people, our viewers?
I would say to the viewers, please, please, please make sure you keep all the available evidence in hand.
Hmm.
Even we end of the day, we all are human. We forget things. So soon you enter into any agreement. If you cannot keep the evidence available, write it down somewhere in your diary as a note.
Hmm.
What was agreed between the parties? And all the correspondences you made with your counterpart. Keep all the emails, keep all the WhatsApp, message nowadays takes place. So keep all the available evidence so that if there is any dispute between the two parties, so either party can pursue the claim, or if you defend a claim, so that you have a solid evidence to defend a claim.
Hmm. All right. Thank you so much. Your advice was really helpful, and I believe the audience will be find it helpful as well. So definitely, if you have got any issue with your money claims, or if you think that you have got a money claim but you are looking for legal advice, definitely you can join. I mean, contact Mr. Shah at the given number and the email. So thank you, Mr. Shah. If you have got any last words for our viewers.
The last word is that nothing is more important than your life. So don't involve with any dispute. But if there is any dispute, don't take it as any stress. Contact with your local solicitor who has the knowledge in this area of practice, and give all your stress to them, so that they can look after your best interest.
Definitely. So I believe the audiences will do that. Thank you so much for joining us
No
today.
problem. Thank you for having me. You have a
Thank
lovely
you.
evening.
Bye.